cybersecurity law guy. And when I think about cybersecurity law, I had always been like, I got to know Puneet very recently, but Prashant and Pavan I know for a pretty long time. I can't think of a better panel of experts if I had to go and take advice from. So I believe for the audience, as far as at least I know, I can't think of a better audience. So I'm personally super excited to actually learn from this session. So my background had been more on the technical side, and I knew that this thing is brewing. Finally, the privacy bill has become. How GDPR takes care of it from the perspective of how big the company is in terms of revenue. How does the Indian Act take care of in terms of how much will be the fine?
Okay, so let me first give the highlight from, because other two speakers have spoken about from the corporate point of view. Let me take the data principles point of view, you and me. So if you and me are losing data, the highlight is we don't have any compensation from the government. In fact, if you don't follow the rules and because of which you have lost the data, you may be charged, you may have to pay a fine of rupees 10,000 to the data protection board. Okay, so that is the provision. So a very
That's
a different provision altogether. Yes, you can.
But here even you're already sucked into the whirlpool. So any expectation or any representation that, look, we are not covered under the DPDP Act must instantaneously evaporate. That's the first thing. Number two, broadly speaking, this law has come up with three broad concepts which are alien in the Indian ecosystem, but people need to know about it. We have the concept of data principal, data fiduciary, and the data processor. Now, we need to appreciate that India is coming from a historical standpoint where sharing has been the norm of life. We've all been in joint families, we've been sharing information. There's the classical joke that by the time you close your railway journey, you know far more everything about your co-passenger and stuff like that. But in a country like ours, for the first time, the law has now begun to start getting into action. The law says if you are a data principal, then you are the owner of your data, your personal data, which means that nobody else will be able to use it without your specific consent or under certain specified circumstances. The second concept is that of a data fiduciary. Data fiduciary is a concept where the law says is a legal entity who will determine what kind of processing of the personal data of the data principal will have to take place. And of course, the third category is data processor, where the entity is only processing data, personal data, of a data principal for and on behalf of a data fiduciary. So everything is very clear. We are all covered. Of course, the government wants to give us some interregnum period of preparation. And the interregnum period is necessary because for the first time in the history of independent India, we now have unprecedentedly heard fines of 250 crore rupees per contravention. So assuming you are an entity, you don't comply, that does not mean that you can subscribe to the Indian Jugaad School of Management and yet also rest on your laurels. I think with the advent of the IT Act, the IPC amended, and the DPDP Act, the Jugaad in the Indian ecosystem of electronic data